Good morning, everyone, and thank you for joining us by webinar today. My name is Corry Clark, and I'm a partner in Fasken's Surrey office. As we begin our live webinar, it's important to address that we are cognizant of the COVID-19 risks in the Lower Mainland and Fraser Valley. Fasken is committed to following the COVID-19 protocols set by health authorities, which is how we can deliver this webinar. To keep everyone involved safe, we are practicing physical distancing, and only those who are required to be in the room for the webinar are present. Before I give you a little background information about our firm, I'd like to give you the order of the day. Today's real estate presentation will wrap up at 10 o'clock so that anyone who has other pressing matters to attend to can get on with their day. After the presentation, our panelists will be available to answer any real estate related questions you have during the Q&A period, which will continue until 10:30. Questions are to be submitted in the Q&A box to the right of the video player on your screen. Our moderator will confirm the receipt of questions and will pass your questions to our panel at the beginning of the Q&A period. About Fasken. Fasken is a full-service, Canadian-based international law firm. Our firm has been in Vancouver for over 130 years, and in early 2018, recognizing the phenomenal growth and sophistication of Surrey's business community, we expanded our service offering south of the Fraser, and we can now be found at Station Tower on 108th Avenue, where we are now. Fasken is very pleased to be a member of the Surrey Board of Trade and the Downtown Surrey Business Improvement Association, and our firm and our lawyers are actively involved in the community in a variety of ways, including sharing our expertise on various topics with the business community. This morning, it is my pleasure to welcome you to the fourth session in Fasken's seminar series in Surrey. Fasken sees a great benefit to working with businesses in our local communities, including those in Surrey. We also recognize the value of partnering with local businesses which have global connections. To help small to mid-sized companies grow and access Canada's top exporting resources, we support programs like the Trade Accelerator Program, or TAP, and International E-Commerce Essentials, or ICE. Programs like TAP and ICE can help position your company to reach its full potential. You will find more information on these programs attached in our post-event email. Fasken services all sectors of business. Our real estate group is well established and works with real estate developers, private institutional investors, financial institutions, pension funds, insurance companies, and crown corporations. Our firm-wide real estate group is a seasoned legal team with the experience and capacity to take on complicated and sophisticated transactions. This morning's seminar will be led by three members of our BC group, including Sarah Batut, Ravi Bindra, and me. Again, for those who may have joined late, I'm Corry Clark, a partner in the Surrey office. I practice in the areas of civil litigation and arbitration with an emphasis on commercial disputes and real estate disputes. I also provide strategic corporate governance advice to officers and directors of companies. Sarah is a real estate partner in the Vancouver office. In dealing with real estate transactions, Sarah's clients appreciate her deep experience in a broad range of issues, including acquisitions and sales, financings, and commercial leasing. Sarah is also experienced in a variety of corporate commercial transactions, including acquisitions, sales, and reorganizations. Last but not least, Ravi is a real estate associate in the Vancouver office. He advises clients on a broad range of legal matters, including acquisitions and dispositions, leasing, financings, construction contracts, restructuring, and corporate agreements, such as shareholder agreements and joint venture agreements. Please be aware that the slides you will see in today's seminar will also be distributed after the presentation. We'll also be distributing a feedback survey following the webinar, and we encourage you to fill that out. We're now going to begin our presentation, starting with Ravi.
Thanks, Corry. So the title of our presentation is The Bad Times, Navigating Real Property Investments and Challenge During Crisis. The first topic of the day is going to be conserving cash and working with lenders, which I'll speak about. So under the cash conservation topic, The basis of this entire discussion is going to be that given the COVID-19 pandemic, there's a cash crunch, and tenants, both tenants and landlords and purchasers of property are going to need to come up with ways to conserve cash in order to meet their day-to-day working capital requirements, etc. So some strategies to deal with that are rent deferrals and government programs that have been that rent deferrals directly with landlords, or government programs provided by the government. In order to get rent deferrals, though, tenants will need to engage with their landlords to have discussions in order to discuss the possibility of rent deferrals. As a landlord, if you are granting rent deferrals, it's important to understand that your cash flow, you'll want to run your cash flow and a run scenario to make sure that if you do have any mortgage obligations, that you're able to ensure that any rent deferrals granted don't significantly impact your ability to pay your lenders. We'll be talking about government programs a bit later on in this discussion, so I'll leave it at that for now. As a landlord, another option for you to conserve your cash is to reduce services in buildings. Given the current COVID-19 pandemic, a lot of tenants are working from home or have flex workspaces right now. So the buildings aren't necessarily at full capacity. So a landlord can undertake cost-saving measures by reducing operations and minimizing ongoing care and maintenance on that basis. From the perspective of a purchaser who's acquiring property during these times, a great option to conserve cash is to delay closings. Of course, if you've waived subjects and you've gone firm on your deal, this may not be possible unless the vendor agrees to it. However, if there are subject conditions still not waived, then you have the possibility to engage in this discussion, especially if coming up with the cash to close is an issue. And if you're thinking about entering into a contract at the moment, we would highly suggest that you think about including clauses that allow you to delay the closing as a result of the COVID-19 pandemic. This would allow you to manage your cash in a sustainable way. Another option from the perspective of a vendor that needs cash is to take an assessment of all your core property assets and decide what are your non-core assets and what are the core assets that you do decide that you want to hold long-term. And you can end up selling your non-core real estate property, and as part of that transaction, enter into a leaseback. So you get an influx of cash. At the same time, you'll still have the ability to make use of that property through a lease. Lastly, if you do have credit lines, you may want to consider tapping into those credit lines just to increase your cash position, and also pursue an increase in any of your existing credit lines. This will allow you to meet your short-term obligations and provide short-term liquidity tools available when necessary, as we've entered into that second wave of the pandemic. The next topic is working with lenders. So if you are a borrower that's feeling a cash crunch at the moment, it's important to engage communication with your lenders early on so that they've got a full knowledge of what's going on. Generally, lenders would appreciate having an upfront discussion about this rather than kind of being blindsided by any issues with repayment of debt. So we'd highly recommend that if you are in a position where in the foreseeable future that you think you're going to need a bit more time to make payments or other arrangements with your lenders, you should make sure that you reach out to them early. With respect to debt covenants on your existing loans, a borrower will want to make sure that they review them early on to ensure what the required covenants are in order to anticipate falling below required debt covenant levels. Again, you should be proactive in reaching out to lenders in order to discuss any issues you may have with meeting your debt covenants. Generally, lenders understand that it is a unique situation with what's going on around the world, so they'll be more responsive to a borrower that's willing to engage in early communication as opposed to blindsiding them. Thirdly, another key consideration is timing. So if a collaborative approach is contemplated, generally you want to take quick action so that the parties have the benefit of conducting their due diligence and ensuring that they've got full knowledge before making a decision. Again, if you are communicating with landlords or with lenders at the last minute, that can cause issues and causing further delays, because usually lenders will want to know exactly what's going on in order to make their decisions revolve in regards to granting any forbearances or any such other arrangements. So the next deal when you're working with lenders is a forbearance agreement. This is a document that's entered between an existing lender and a borrower, whereby the lender will agree to refrain from taking any actions under its loan and existing security. I'll be talking about forbearance agreements a bit later on, but in general, it's basically the lender will waive its rights for a certain period of time in order to grant the borrower some more time to preserve cash and such. And then the last concept is the priority and standstill agreement. So if you're a borrower with multiple lenders that have multiple mortgages on title, as part of any arrangement that you enter into with the first lender or the second lender, you'll likely have to also enter into a priority and standstill agreement. The main provisions of this agreement is subordination by the junior lender in favor of the senior lender of its security, and then also a postponement by the junior lender in favor of the senior lender of its rights to be prepaid. Generally, this document is negotiated directly between the first and the second lender, but it's an important document because it can be a condition to any forbearance agreement or other arrangements that will be entered into. Right, so as I mentioned that previously, forbearance agreements is one of the options whereby a borrower who's having difficulty meeting its debt repayment obligations can approach the lender. The purpose of the forbearance agreement includes providing more time for the borrower to repay its debts. It temporarily suspends repayment, and it provides from the perspective of the lender, provides it the opportunity to maximize its profitability and increase the likelihood of recovery and preventing an event of default. In addition, a forbearance agreement will usually clarify and resolve disputes between the borrower and the lender, so it sets a mutual expectation for repayment in the future. In terms of benefits for the lender, the forbearance agreement will allow the lender to obtain additional security. In addition, it'll allow the lender to collect additional interest payments and also allow the lender to require additional capital injections into the property. So it allows the lender to secure its position further. And from the perspective of the borrower, the main benefit is that it can prevent foreclosure and allow deferred payments, which allow you to increase your cash position and also kind of allows the borrower to get its house under order. And then one of the big benefits for the borrower is if it also allows the borrower to avoid any additional expenses of defending claims by the lender. So it's really helpful from the perspective of the borrower. However, there are some risks and pitfalls. So forbearance agreements are agreements that where you'll want legal advice. For instance, when borrowers providing additional security at the request of the lender, there needs to be an analysis of whether that security is reasonable and what that security relates to. In addition, a borrower may be required to pay additional fees and interest payments. So there is a potential for injecting cash initially. And lastly, one of the key concerns of a forbearance agreement is, as a borrower, you want to make sure that if you enter into a forbearance agreement, you're able to meet the ongoing obligations at the end of the forbearance period. If that's not a possibility, then you're initially just buying yourself time, but you're going to end up coming to that same result at the end of the day. And you'd either have to enter into another forbearance agreement if you can't meet your debt obligations, or the lender may take action to foreclose on your property. So it's really important to make sure that whatever terms the borrower agrees to in the forbearance agreement are obligations that the borrower can meet both during the forbearance period and after the forbearance period. And then the last issue or topic under forbearance agreements relate to priority and standstill agreements, as previously mentioned. Generally, forbearance agreements that are entered into will require priority and standstill agreements if there are multiple lenders with mortgages on the property. In addition, if a forbearance agreement is being granted by the first lender, it'll generally seek a forbearance agreement under from the second and third lender as a condition. So it's you'll want to engage all your lenders early on and ensure that there's enough time for them to settle the priority and standstill agreements. The second topic of the day is a recap of government responses to COVID-19. So we'll talk about the federal government response and then the BC provincial response, and then also touch upon what's next. So the federal government response initially was to provide mortgage default assistance. This was provided to loan-to-value mortgages funded to date effective March 20th, 2020 for eligible government guaranteed insurance. The low loan-to-value mortgages applied to mortgages with a maximum amortization term of up to 30 years. The eligibility criteria for government guaranteed insurance continue to apply for these mortgages. The other big program that the government came out with was CECRA, which was applicable from April to September 2020. This program has now expired, but the general gist of this program was that the government provided forgivable loans to commercial property owners to cover up to 50% of the rent payments payable by small business tenants. As part of this program, the tenant was required to pay between 0 and 25% of their normal gross rent, with the property owner paying from 0 to 25% as well, and the government paying the balance. And then to enter into this agreement, there needed to be a rent deferral agreement between the landlords and tenants, and then you'd apply for a government assistance. However, recently there's been a replacement program called the Canada Emergency Rent Subsidy Program that was announced. This provides access to both rent and mortgage support until June 2021 for qualifying businesses, and it also includes not-for-profits. This provides a subsidy of up to 65% of the rent or mortgage interest payments that see revenue decline of at least 70% until December 19th, 2020. And there's a gradual decreasing level of support in line with revenue. So if revenue decline is less than 70%, the subsidy reduces accordingly. This program provides a direct rent support to qualifying tenants without needing to work through arrangements with their landlords. So there's no rent relief agreement that needs to be entered into between landlords and tenants. And it's structured as a subsidy, whereas the original CECRA program was structured as a forgivable loan. So by entering into the new Canada Emergency Rent Subsidy program, there's no requirement to enter into a loan agreement whatsoever. The maximum amount that a tenant can claim for a property is $75,000 per location. So if you're a tenant that has multiple locations, you're only entitled to receiving $75,000 per location and a maximum aggregate amount of $300,000. Just for clarification, however, the maximum subsidy amount applies to that $75,000. So the maximum subsidy is 65% of that $75,000 limit that you're allowed to apply for. So the maximum subsidy that a tenant may receive is about $48,000 for a qualifying period. The next topic's the temporary, the residential aspect that the BC government has responded with for residential tenants. So there was initially a temporary rent supplement whereby the government was paying for a portion of rent owed by tenants. The tenants would apply for this program and the funds would be delivered to the accounts of the landlord. In addition, the BC government had responded with a moratorium on evictions, which has been lifted for the ban on evictions has been lifted for a certain reason. However, there's still a moratorium on increases on rent or unpaid rent. So for now, landlords will be able to serve eviction notices to landlords, or landlords will be able to serve eviction notices for landlord or purchaser use and for cause. Once the moratorium, however, is lifted, the tenants will be responsible for paying back any rent that they owed. In addition, there's been a rent freeze, so no further rents can be increased on residential tenants. And the government has also implemented a rent repayment framework to allow tenants that were unable to pay a rent during the first wave of COVID-19. Lastly, the BC provincial government has also extended the early marketing period for development properties under REDMA. So this provides developers with the continued access to the 12-month early marketing period instead of the usual 9 months, and this was effective since July 15th, 2020. So what's next? I'm sure, as many of you may be aware, on November 30th, 2020, the Landowner Transparency Act will come into force. The Landowner Transparency Registry will be implemented notwithstanding COVID-19 delays. So if you do have a closing on November 30th, you'll be required to submit a transparency declaration. And if you are a relevant corporation or a relevant trust, etc., you'll be required to file a transparency report. These forms aren't yet available. So if you do have a closing on the 30th, you'll want to get in touch with your notary public or your lawyer to make sure that you're available to sign any documents once these become available on November 30th. Any existing property owners will have a year to file these reports, but if you're acquiring new property, from and after November 30th of this year, you'll be required to make these filings. The result of the Landowner Transparency Registry is that a database of beneficial ownership will be created that'll be searchable. However, there are certain exceptions where you may be able to prevent your information from being released, but again, that's a very limited circumstances. The registry won't be searchable initially. It'll be until the registry won't be launched until April 2021. So there's still a bit of time, but I think everyone will need to be aware of that as you enter into real property transactions here in BC. There will be additional disclosures being made. So as a result, your notary public and your lawyer will be asking for further information to understand the ownership of properties.
Thank you, Ravi. So I'm Sarah Batut, and I'm going to discuss force majeure and negotiated lease options. Bear with us, due to COVID requirements, we only have a certain number of clickers, so Ravi's going to try and follow through with me, but I'll go from there. So first of all, I'm going to talk about force majeure. It's probably a term you've heard a fair bit of while during the pandemic. So most leases and commercial agreements contain a force majeure, or otherwise known as an unavoidable delay clause. The general concept is that if an unforeseen event occurs that prevents the parties from fulfilling their obligations under the contract, the parties are excused from performance of such obligations until that event is over. The event must be something that is beyond the reasonable control of the party, and the party must take reasonable steps to mitigate it. So is COVID a force majeure event? The typical lawyer response: it depends on the wording of the force majeure clause. Many force majeure clauses list types of events that constitute an unavoidable delay, such as labor disruptions, i.e. strikes, inability to obtain supplies, terrorism, acts of God, etc. Some do reference disease outbreaks, but pre-COVID, that was not that common. Although in Ontario, after the SARS outbreak, you did see a bit more in Ontario documents. If there is a general catch-all in the clause, such as other reason of like nature, not the fault of the party delayed, then it's likely that COVID would be considered a force majeure event. An example clause is, except as otherwise provided in this lease, in the event that either party, in good faith, is delayed or prevented from doing anything required in this lease by reason of strikes, lockouts, labor troubles, inability to procure materials or services, failure of power, restrictive governmental laws, orders or regulations, riots, insurrection, war, or other reason of a like nature not the fault of the party delayed or prevented, then performance of such act shall be excused for the period of the delay, and the party delayed will do what was delayed or prevented within the appropriate period after the delay. So this clause, while having a long list of possible events, does not specifically reference a pandemic, but it does have the or other reason of a like nature, meaning it would likely capture COVID. In order to rely on the force majeure clause as a result of COVID, COVID had to have actually caused the delay. For example, if the supplies for a project came from China and the manufacturing facility was shut down during the initial outbreak, and that meant you were unable to obtain the supplies, then that would be considered a force majeure event. But if there was a reasonable alternative, then it could be argued that the party should have availed itself of such an alternative to mitigate the delay. A key item to note for leases is that most commercial leases provide that notwithstanding any force majeure event, the tenant is not excused from paying rent. Therefore, notwithstanding any issues the tenant may have as a result of COVID, it is still obligated to pay rent under the lease. We anticipate a slew of litigation on force majeure in multiple contexts. I'm not aware of any Canadian cases having been decided yet, but I do know that a number of them have been started. I'm next going to talk about rent deferral and abatement. Ravi has already spoken about SECRA, which is now at an end, and the Canada Emergency Rent Subsidy, which doesn't require anything from the landlord. So I'm going to focus on negotiated arrangements. Landlords want to continue to receive rent to cover its mortgage payments, to pay operating costs like property taxes. They do not want to go through the process of reletting the premises and incurring costs such as commission, landlord's works costs, tenant inducements to get a tenant into the space. Further, for retail environments, landlords don't want dark storefronts. A tenant's business may have been significantly impacted by COVID, such that their revenue stream is insufficient to cover rent plus the employee's salaries, costs, etc. But the tenant is hopeful that it can make it through the pandemic if they receive some assistance with rent. This means that many landlords are willing to work with the tenants to a certain extent. One option is the landlord agreeing that for a certain period of time, all or a portion of the rent is deferred, and that the tenant will repay such deferred rent in the future when it is hopefully back up and running. The deferred rent is either repaid in a lump sum payment or what I've seen more commonly over a period of months. Often leases include provisions that interest is to be charged on amounts not paid when they are due. Landlords need to consider whether or not they will charge interest on the deferred rent. For the rent deferral, landlords need to consider whether it's just a deferral of the minimum or basic rent or whether it's a deferral of the gross rent. A good option for the landlord is to just defer the basic rent and require the continued payment of the additional rent so that the landlord still has some cash flow coming in to cover the operating costs. As Ravi mentioned, most landlords are probably mitigating their operating costs right now due to less capacity in the buildings and less just wear and tear from people. One concern for landlords is whether they will actually recover such deferred rent and should consider whether there's any security they can take for such deferred rent, such as adding an indemnifier to the lease, obtaining a personal guarantee, or perhaps a general security agreement over the assets of the tenant. For rent abatement, this is where the landlord forgives rent for a certain period of time and there's no obligation of the tenant to repay that forgiven rent. In some circumstances, we're seeing a combination of both a rent deferral and a rent abatement. Tenant continues to pay a portion of the rent, a certain portion is deferred to a later date, and the landlord forgives a certain portion, sort of mirroring what the SECRA program contemplated. In both cases, landlords are advised to obtain the consent of their lender to such arrangement with the tenant. Most security will provide that there can be no material changes to the lease without the landlord's consent. A real-life example of these negotiations, pulled from the headlines, is what is going on with the Bay. You've probably seen in the news that the Coquitlam store has been shut by the landlord for non-payment of rent. This has also happened in other provinces. In Ontario, it's already gone through the court system, and the court agreed that HBC could not be evicted given the current circumstances, but was ordered to pay 50% of the outstanding rent. In Quebec, the court, on multiple applications from different landlords, ordered the Bay to pay its rent. The Bay is taking the position that it wants landlords to share the pain. As we've discussed, the landlord still has bills to pay. If the large anchor tenant, presumably with the resources to weather this storm, doesn't pay the rent, then the landlord doesn't necessarily have the resources to be able to offer deferrals or abatements to the smaller tenants, the local businesses, the so-called mom and pop shops. The Bay is not the only tenant using the strategy of not paying rent. They are the one in the headlines right now. At the beginning of the pandemic, Canadian Tire was, at least in the real estate world, was in the headlines because it wasn't paying rent at the start of the pandemic. I'm not sure what the status is with them. I'm aware of a number of other large anchor tenants that wasn't paying rent during the pandemic. In some cases, they've now paid back that or come to arrangements with the landlord. These large anchor tenants are likely relying on the strategy of, even if we don't pay the rent, the landlord is most likely not going to terminate our lease because we're the anchor tenant, and it's going to be very hard to fill that space. The last topic I'm going to talk about today is early termination. So unfortunately for tenants, the bulk of leases do not include the right of a tenant to terminate the lease early. If a tenant is looking to get out of its lease, it can attempt to negotiate with the landlord for the early termination. As I mentioned, reletting costs the landlord money. They're likely going to lose rent for a period of time, will likely incur leasing commissions, may incur costs for landlord's work and tenant inducements, whether that's free rent for the tenant or a tenant improvement allowance. Therefore, if a landlord is willing to agree to an early termination of the lease, they're likely going to want to receive some form of termination payment from the tenant, and the tenant may not have the resources to make such payment because of the pandemic. They want out of their lease because they don't have the money to keep paying the rent. A key benefit of a mutual termination agreement is that they typically include a mutual release of the tenant and landlord from any liabilities under the lease. I'm now going to turn it over to Corry, who's going to speak about what happens when it all goes wrong.
Thank you, Sarah. And unfortunately, sometimes it does all go wrong, and that's when litigation lawyers such as myself get involved. But before I sort of turn to some options for landlords and tenants when the wheels fall off the bus of the commercial lease, just want to touch briefly on Ministerial Order number M179. Ravi spoke a little bit about the program called SECRA that provided assistance to landlords and tenants during the first part of the pandemic. When that program, after that program was announced in May of 2020, the provincial government came out with a ministerial order that limited the ability of commercial landlords to terminate leases. It did still allow landlords to sue on rent, but it didn't allow landlords to end a lease, to shut the door against the tenant. That ministerial order ended with the end of SECRA. And so there's a bit of a backup kind of in the litigation system with respect to commercial landlords terminating leases. I raise it only because with this new program, it is possible, and I have no inside knowledge on this, it's possible that we'll see a new ministerial order with similar terms that may limit the ability of landlords to terminate leases. So watch this space, because something else may come down the pipe. Or not. We need a crystal ball with these things. In any event, so when negotiations break down with the tenant, the landlord has some options. The landlord can sue the tenant for non-payment of rent. The landlord can terminate or end the lease. The landlord can also detain, the word that lawyers use is distrain, the tenant's property for rent due. Note that the ability to terminate the lease and the ability to distrain the plaintiff's or the tenant's stuff is mutually exclusive. You can't terminate a lease and hold on to the plaintiff's, or pardon me, the tenant's stuff. So at some point, the landlord has to make some choices about what they want to do when a relationship has broken down with the tenant. And finally, the landlord can re-enter the premises to take steps to rent out the premises on the tenant's behalf. I don't have a ton of time, so this talk is sort of a 20,000 feet up overview of only some of these issues. As you can see on the slide, I'm going to talk about a rent distress, which is also known as distraining a tenant's property. I'm also going to talk about termination of the lease, and I'm going to talk about a topic called relief from forfeiture. Forfeiture is basically the termination of the lease by the tenant or by the landlord in circumstances that are disputed. Rent distress is a self-help remedy that allows a landlord in a commercial tenancy, not a residential tenancy. So rent distress is only available in a commercial landlord-tenant relationship. It allows the landlord to hold the goods of the tenant that are found on the leased premises as a form of security for the payment of rent arrears. So the landlord can hold the goods belonging to the tenant that are found in the leased premises as a form of security for the payment of the arrears of rent. Rent distress arose at a time when tenancies were largely agricultural. As a result, this area of the law has some arcane rules which are well beyond the scope of this presentation. It's a technical process with lots of trapdoors for landlords and some limitations that tenants can exploit. So if you come across a rent distress issues, either as a landlord or as a tenant, we would recommend that you get specific legal advice to address your situation, because obviously every situation is different and there's different strategies and considerations. I want to highlight some general things to keep in mind with respect to rent distress. So to start with the obvious, it's illegal to distrain or to continue with rent distress when no rent is due. Rent distress can only be applied to outstanding rent, not to any other fight over money between a landlord and a tenant. Second, a landlord or her bailiff does not have the right to force entry into leased premises for the purposes of rent distress, and doing so could result in forfeiture of the lease and make the distraint illegal and the landlord potentially liable for trespass. There are provisions in commercial leases which set out when a landlord can enter onto property and when he or she cannot. And so if you do not distrain or seize goods appropriately, you could actually be liable for trespass. The general rule is that rent distress may only be levied against goods in the leased premises. So if the tenant has leased space or owned spaces somewhere else, that is not eligible for the landlord to seize those goods to secure the payment of rent. It's only on the space that that tenant has leased within the respect of that specific relationship. There's one exception, and that is created by the Rent Distress Act, that allows the landlord to go onto a different site to seize goods which have been fraudulently or clandestinely removed from the premises by the tenant. This is a specific statutory exemption to the general rule, and the landlords must comply strictly with the provisions in the Rent Distress Act to claim the benefit of this exemption. Fourth, the landlord can only distrain goods owned by the tenant. And this comes up in circumstances where a business may be operated by a joint venture or other arrangement where the tenant may be company A, but the goods the tenant is selling in the leased space is owned by company B, another participant in the joint venture. And so landlords have to be careful, because you can't take the stuff owned by company B. You can only take the stuff owned by company A, so you got to do your homework here. Fifth, the landlord cannot restrain goods if the tenant is bankrupt. Sixth, rent distress can't be undertaken if the tenant is no longer in possession of the leased space, if the distraint is more than 6 months after the expiry of the lease term, assuming that the tenant is still in possession of the space, if the landlord or tenant relationship has ended, or if the lease has been terminated. Seventh, the landlord should not seize more goods than are required to satisfy the rent due, or the distraint may be found to be excessive and set aside by a court. Before I move to the termination of leases, I just want to say a word about what the tenant can do if it believes that the landlord has seized or distrains its goods improperly or illegally. The tenant can start a lawsuit asking the court to force the return of the goods and can claim damages. This type of lawsuit this type of action is called replevin, and it's governed by Section 57 of the Law and Equity Act. In such an action, the courts can order a return of the property to the tenant, sometimes on terms requiring security with respect to those goods. The court can make a final order that distraint was illegal, or can make an interim or sort of order until trial. And the court can also order damages. So turning to termination of the lease. As I note on the slide, a landlord needs to look at the lease to determine the process for determining it. The default provisions of a lease will generally require the landlord to give a formal notice of default to the tenant, setting out the alleged defaults and requiring these defaults to be cured or remedied within the time period specified in the lease. You've got to read these default provisions carefully, because a failure by the landlord to comply with the notice provisions under the lease may result in the termination not being effective, and the tenant may be awarded both general and punitive damages for wrongful termination. Before deciding to terminate a lease, the following questions should be considered. Is the alleged breach by the tenant clear, or is it more subjective? Like, for example, a clear breach is a failure to pay rent, because it's obvious whether the money's been paid or not. A less clear breach is whether the tenant has been abiding by a covenant in the lease to keep the premises in good repair. That may be in the eye of the beholder. Terminating a lease is a dangerous strategy if the alleged breach is subjective or arguable. Another consideration is how significant is the breach. You don't want to mess around with the process of terminating a lease for a minor breach, because that's not worth the heartache for the landlord. Does the tenant dispute that the lease has been breached? And does the tenant say that the breach has been rectified or fixed? Has the tenant indicated that it will not leave the premises? The reason why this is a consideration is because the landlord may then be required to go to court to get an application for an order for possession of the property after termination, and that can be an expensive and time-consuming process. In general terms, judges don't like terminating commercial leases because they can have significant economic value to the tenant. The decks are really stacked here for the tenant in this area of the law, unless the landlord has an unequivocal basis for terminating. And as I said before, leases should not be terminated for trivial breaches. If the landlord decides to terminate the lease and proceeds to do that, the landlord should then be careful to take no steps that could be construed as a waiver of the termination, such as allowing the tenant to remain in possession of the space. A failure by the landlord to comply with the notice provisions under the lease, as I said, may notice in the termination not being effective, and the tenant may be awarded both general and punitive damages for wrongful termination. And the reason why you sometimes see punitive damages is because of, as I mentioned, the economic value of some of these leases to the tenant. That's where that's literally where their business runs out of. And if they don't have that space, and if they've got years of exposure in the market at that particular location, it can be devastating for a tenant. And courts are not going to be pleased if a landlord acts inappropriately or outside what the lease says with respect to the termination, if it's going to cause that kind of damage to a tenant. From a tenant's perspective, a tenant, as Sarah noted, most commercial leases don't provide for early termination by a tenant. But where it does, the tenant should also very carefully review the lease to see if there's a possibility for early termination if the tenant wants to do that. A tenant can also end a lease where it has been deprived of substantially all the benefit. For example, where a landlord has failed to get an occupancy permit from the relevant municipality such that the tenant isn't actually able to run its business out of the space. That's a loss of substantially the benefit of the space, of the lease, because you're paying to be able to use the storefront and you're not able to access it. If the tenant is able to end the lease, it should do so under the terms in the lease and then should move out promptly, assuming that they were able to move in the first place. The final topic that I want to talk about today is called relief from forfeiture. Forfeiture it basically is termination, a disputed termination of the lease by the landlord. Excuse me. And relief from forfeiture is a sort of a judicial procedure by which the tenant can reinstate, can have the lease judicially reinstated by an order of a court. It can be invoked by a tenant as defense to a landlord's claim for possession of the leased premises. And a judge can make an order to reinstate a commercial lease under Section 24 of BC's Law and Equity Act. In order to be successful in a court application for relief from forfeiture, however, certain prerequisites must first be satisfied by the tenant. First, there must have been a proper and valid forfeiture by the landlord before the tenant can be given relief from forfeiture by the court. So, in other words, the tenant must be able to show that the landlord has actually terminated the lease. Second, the party seeking the relief from forfeiture in the court must be the proper party. This is most significant where a lease has been assigned, because it's the assignee and not the original lessee who is the proper party to seek the relief. Although the original lessee may actually still have obligations under the lease, they can't be the party to bring a proceeding for relief from forfeiture. And third, at the time of the application, there must be some portion of the term of the lease remaining before relief can be granted. A lessee cannot retain possession under the lease if the lease term has expired. If there's not 5 more years on the lease. If it was over as of October 31st and you're going to court on November 2nd, it's not going to help you very much because the term of the lease is over. Fourth, relief from forfeiture can only be granted if there's no intervening third-party interests, such as a new lease with a third party with no notice of the dispute between the original tenant and landlord. And fifth, Section 28 of the Law and Equity Act in BC says that a tenant cannot receive relief from forfeiture more than once in respect of the breach of the same covenant or condition. What that means is that if I'm a tenant in a commercial space and I failed to pay rent, I got a court order undoing the termination of my lease as a result of my failure to pay rent. And then later on, I again failed to pay rent and the landlord terminates the lease. I can't then seek relief from the court to reinstate the lease again for that second time. It's sort of a one and done kind of thing. In determining whether relief from forfeiture is appropriate, the court's going to look at all the circumstances of the case. They're going to consider the conduct of the parties to sort of assess the equities or the fairness between them. But they're specifically going to look at the conduct of the tenant. That's like sort of a key judicial consideration for the court. The court's going to look at such things as the tenant's previous substantial compliance with the lease, whether the breach is relatively trivial, whether the tenant had an honest but mistaken belief that gave rise to the breach, i.e. if I understood that I had to pay $50 of rent when it was really $75, and that was, I genuinely believed that, I honestly believed that, but I was wrong. And finally, if the tenant is willing and has the ability to remedy the breach quickly. A tenant will increase its likelihood of getting the lease judicially reinstated by demonstrating the severe consequences of the termination of the lease on it. For example, the loss of the lease as a long-term asset. If the tenant can show that there will be material damage to its business as a result of the termination of the lease, if it can show that it will lose loss of investment, it'll lose the investment in the property, or whether it can show that there is disruption to employees. In defending a court application for relief from forfeiture, the landlord should seek to rely on its financial losses and other forms of prejudice likely to result from reinstatement. You're more likely to see these types of arguments where there is a lease to a new third party of the space. Generally speaking, because there is no overall rule in law, but in general terms, relief from forfeiture will be granted when the landlord can be made whole by money. The court, even if a landlord can be made whole by money, the court may want to impose terms with respect to like a payment schedule or payment plan with due dates so that rent doesn't fall behind. But if the landlord can be fixed by cash, the court's more likely to grant relief from forfeiture. And other things being equal, relief from forfeiture is likely to be granted when the offending situation can be quickly remedied and the status quo restored, whether this is by money or otherwise. So if you're a landlord, you should maintain a good record of tenant breaches and misconduct to enable you to argue against equity or fairness of granting forfeiture relief. So identify breaches and misconduct to the tenant in writing. Lawyers love a paper trail. In writing, to protect yourself from the situation that for some time having allowed conduct that's at odds with the lease, you're then the tenants later are able to argue, well, that since you let me do that differently, then this new status quo is what governs us going forward, and then a court may agree with them. So you want to make sure you don't create a pattern of conduct that looks like you're agreeing with the tenant unilaterally making changes to the lease, because later on, you may be bound by those changes. The landlord should also not accept rent for the period beyond the alleged lease cancellation unless this rent is paid, is accepted expressly without prejudice to your right to argue that the lease was validly terminated. And if you're a tenant and the landlord has terminated your lease, you should move as quickly as possible to fix the breach, i.e., pay the unpaid rent immediately to the landlord, or if the landlord refuses to accept it, entrust with its lawyer or your lawyer. You should move quickly to bring a court application to seek relief from forfeiture. Delay is not an option here. You cannot sit around and wait to see what happens. A delay that leads to a reletting of the premises to an innocent third party could be determinative against any application that you might later make to get the premises back. So fix the breach, act fast. So this has been your whirlwind tour of some of the issues arising in commercial leasing disputes. Lawyers routinely give 1 and 2 day seminars on these types of things, but I would caution and say that in any given situation, your mileage may vary. These disputes, like all disputes, are extremely fact dependent. So please obtain legal advice that addresses your specific situation. There is a lot of trap doors in this area of the law, in terminating leases, in distraining goods, in relief from forfeiture. So make sure to get advice which suits your specific situation. Well, thank you everyone for joining us for today's seminar. We trust that you found it to be informative, Fasken's next seminar will focus on trusts, wills and estates, and charities. And this is going to be held in February 2021. Details about the seminar will be released in January. We encourage you to register, and we do hope that you will connect with us once again. So as I mentioned at the outset, for those of you who have to leave, thank you for coming, and we hope to see you again. For those of you who can stay and who have a real estate related question, Sarah, Ravi, and I will be happy to address such questions. Please submit questions via the Q&A box on the right-hand side of your screen. Our final wrap-up will be at 10:30, or if questions end sooner, when that happens. If you need to leave, or if there isn't enough time for all your questions this morning, you can email them to surrey@fasken.com, and they will be answered as quickly as possible. And please fill in the feedback survey when you receive it, as this will help us tailor future seminars. So I'm going to turn it over to Sarah, who's going to lead us in the Q&A period.
Thanks, Corey, and thanks, everyone. So I believe the questions may be showing up at the bottom of your screen. We had a few questions that were submitted ahead of time, and I'm going to start with those. So one of the questions we received was, any insight on where the market is heading the longer the pandemic goes on? And so I'm going to answer that one. Corey mentioned having the crystal ball. It's all a bit of crystal ball gazing. And I'm sure our friendly brokers are going to provide us with lots of stats shortly. In general, from what I'm seeing is that on the commercial side, there weren't as many transactions going on for the first part of 2020. I used to be closing about a transaction a week and wasn't closing that many acquisitions or dispositions. That being said, I'm starting to see more of them. Again, talking to my colleagues from other firms, they're also starting to see more of them. And definitely people are looking for deals. As the cash flow impacts landlords, as lenders are tightening up what they think and how much they want their clients to be leveraged. I anticipate that we're going to start to see some dispositions happening where the owners are being forced to do so. And there are still, in the Lower Mainland, lots of entities with funds with the ability to purchase those and get financing still based on their covenant. On the residential market, as you've seen from the news, it's definitely picked up. Things are moving, particularly in sort of townhomes, single-family homes. As we're all going through this pandemic, people are realizing that they want outside space and may not want to go up and down elevators. That being said, on the pre-sale condo market, there are lots of projects going out or starting up. I have a number of clients that are continuing to start sales programs on projects, so still a strong market there. One of the other questions we received was, how effective do you see much mezzanine financing at this stage of the business turned COVID cycle? And Ravi is going to take that question.
Thanks, Sarah. Yeah, so at this stage of the cycle, given that we're now entering, or we're already in the second wave, there is still some uncertainty out there. And given the character of mezzanine financing, that it's short term, I'm not seeing much of it right now, given that there is still uncertainty out there. And if you are getting mezzanine financing, it's at high interest rates, which bakes in the uncertainty. It's effective if you can get it, but again, there's still quite a few people on the sideline just kind of waiting to see what's going on with the business cycle, with COVID, us hitting our second wave. So it's a bit difficult to get at this stage, but if you can access it, it's helpful. As I mentioned previously in my talk, that at this moment cash is king, so it's helpful to get, but again, there's still so much uncertainty as to what's going on, and especially with real estate businesses, for tenants that have storefronts, as we've seen in Ontario, they've entered a lockdown, so that it definitely affects cash flow and the ability to finance this mezzanine, to support mezzanine financing. Yeah.
Thanks, Ravi. One more on the pre-submitted questions, and then I do believe we have some that are being submitted live, per se. With more people working from home due to COVID, what is your forecast for the additional need or reduction of office space in Surrey? So I think what we're seeing is this massive shift to companies realizing employees can work effectively from home. You don't need to have the so-called bums in the seat in the office for employees to effectively have their work done, for businesses to run, and for with all the technology that is now available, such as our webinar happening live with the Zoom meetings, Teams meetings, etc., that we are going to see a reduction in office space that office tenants take. That you were already seeing that, where companies are trying to sublet their space or negotiate with landlords to surrender a portion of their space. And I think even when the pandemic is over, we're going to see that. We're going to see a shift to much more flexible work spaces. The so-called hoteling concept that you see in a lot of the accounting houses, where you don't have this assigned desk, you book in a desk and you're going to come in and you've got something similar to this, not your personalized space. So it will be interesting to see as how the office market goes in terms of leasing, particularly just turning to Vancouver briefly. You know, there's a lot of new office buildings going up. Surrey, there's a lot of new projects happening, some down at Central City, and whether they will be fully leased out. So moving on to the questions that have been submitted. The one that is up on my screen right now is, can a landlord refuse to renew a lease for no reason, i.e. no breach of lease in a commercial situation where the business is actively employing 25 plus employees? So I'll take this unless one of you wants to, jump in on over here.
It's a Sarah show.
It's a Sarah show. It's all me. So it depends on the terms of the lease. So if the lease includes a renewal right in favor of the tenant, you then have to look at the terms of that renewal. Often it will say something such as, so long as the tenant is has been in compliance with the terms of the lease. It may say something about, so long as the tenant is not then in material default under the lease beyond a reasonable cure period. So it does depend on lease, but in general, if there's an actual option to renew in the lease, that is a tenant right, and the landlord cannot refuse to grant that renewal so long as the requirements for the renewal are met. One of those requirements is, when does notice have to be given? It's, not earlier than 12 months, not later than 6 months prior to the expiration of the lease. So the notice has to be given within that period of time, and the notice has to be delivered in accordance with the terms of the lease, which is often requiring personal delivery or fax. On most notice items, what we're doing is we send out an email copy, even if the lease isn't referencing that due to COVID, we're sending you an email and then still couriering it. So it does depend on lease. If there isn't a renewal right in favor of the tenant in the lease, and or if the tenant has been in breach of the lease in past and the option to renew says, so long as the tenant has complied with all that's coming under the lease, then yes, the landlord can refuse to renew a lease. A landlord is not obligated to renew or extend the term of a lease if there is no renewal right within the lease. Then it's a negotiation with the landlord, and the landlord does not have an obligation to renew the lease. The next question, I'm going to make Ravi answer this one, giving you the heads up. Can you confirm if there is tenant relief for residential property owners? So either mortgage deferral and then tenants on rent relief.
Yeah, so there was that temporary rent supplement program that the BC government had implemented over the summer, but that program expired August 31st, 2020. So currently there isn't any residential tenant relief program. As mentioned previously, there is a moratorium on rent increases, and if there were any defaults, there's a program set up so that the tenants can repay any backgoing rent. But in terms of any additional rent programs, we haven't seen any. That's not to say that the BC government may introduce renewed programs in the coming months, especially given, again, we are coming into that second wave. So depending on what results that have on the economy here and just on people generally. In terms of, I guess, general relief for tenants, for residential tenants, I guess it's just wait and see right now.
Thank you so much for joining us this morning. Have a good day. As mentioned by Corry, if there was a question that comes up after this or something that you want to ask us, feel free to reach out to us or to email the surrey@fasken.com and someone will get back to you. Thank you.
Bye.